Have you ever considered how a simple pen stroke can change lives, shape laws, and define justice? Today, we delve into the world of writs, those powerful legal instruments that do just that. A writ is not merely a piece of paper, it is a command issued by a court or a higher authority that compels or prohibits specific actions. Its roots are deeply entwined with the very concept of law and order. Writs serve as critical tools in the judicial arsenal, ensuring that justice is not just a concept, but a delivered reality. They direct authorities to act or refrain from acting in ways that uphold the rights and liberties of individuals. From ordering a government official to perform their duties to halting unlawful detention, the scope of writs is vast and impactful. Through writs, the abstract principles of law are transformed into concrete actions. They bridge the gap between legal theory and practical enforcement, embodying the dynamic power of the legal system to adapt and respond to the needs of society. So let's dive into the historical journey of writs and discover their evolution. Our story begins in the medieval courts of England. During this era, the concept of writs emerged as a pivotal innovation in the administration of justice. These formal written orders, issued in the name of the monarch, played a crucial role in the centralized legal system that was beginning to take shape. The origins of writs can be traced back to the Anglo-Saxon period, but they gained significant prominence after the Norman conquest in 1066. The King's Court, or the Curia Regis, was where these writs were crafted. They served as commands from the king to his subjects, particularly the officials and judges scattered throughout his realm. The purpose was clear: to ensure that the king's decisions and laws were implemented uniformly across England, regardless of local customs or practices. As the use of writs evolved, they became essential tools for the crown to maintain control over its expansive territories. They addressed a variety of issues, from land disputes to the appointment of local officials, and even matters of personal status like marriage and inheritance. The process was relatively straightforward. A subject would petition the king for a writ, and if granted it would be dispatched to the local court for execution, thereby extending the royal influence directly into local jurisdictions. The Magna Carta, signed in 1215, marked a significant development in the story of writs. This legendary document, often hailed as the cornerstone of English liberty, formally acknowledged the importance of writs in the legal framework. It guaranteed that certain legal processes could not be undertaken without a writ, thus ensuring that the king's power was exercised under the law. This was a monumental step towards the rule of law, where even the sovereign was bound by legal procedures. With the foundations set in England, writs began their journey of evolution. This journey saw the transformation of writs from mere tools of royal administration to fundamental instruments of justice, laying the groundwork for the sophisticated legal processes we observe today. As Europeans ventured across the seas, they brought their legal traditions with them. Among these was the concept of writs, a pivotal element of English common law that made its way to the shores of the New World. As British colonies were established across what would become the United States, the legal framework of the mother country took root in this new soil. In the American colonies, writs quickly became an essential tool in the judicial system. These formal written orders, issued in the name of the sovereign back in England, adapted to the unique circumstances and needs of colonial society. They served not only as commands from the courts directing individuals to perform or cease certain actions, but also played a crucial role in the administration of justice. During the formative years of the United States, as the colonies moved towards independence, the nature and use of writs evolved significantly. The American Revolution saw a transformation in the perception and application of these legal instruments. No longer mere extensions of royal will, writs were repurposed to serve a burgeoning democracy, reflecting the changing ideals and demands of a new nation. Judges and legal scholars in the early United States reshaped writs to safeguard personal freedoms and property rights, laying foundational stones for the legal protections we recognize today. Writs such as habeas corpus, which demands a person's release unless lawful grounds are shown for their detention, became symbols of the new American values of liberty and justice. From a tool of royal authority to a symbol of justice in a new democracy, writs were becoming indispensable. Not all writs are created equal. In the realm of law, a writ is essentially a formal written order issued by a body with administrative or judicial jurisdiction. But what sets one writ apart from another? Let's delve into the fascinating variety of writs, which include habeas corpus, mandamus, certiorari, and prohibition, each serving a pivotal role in the justice system. Starting with the writ of habeas corpus, often hailed as the Great Writ of Liberty. This writ commands an individual or a government official who has restrained another to produce the prisoner at a designated time and place so that the court can determine the legality of custody. It is a powerful tool against unlawful detention, ensuring that one's freedom is not unjustly compromised. Next, we explore the writ of mandamus. This writ is a command issued by a court to a government official, agency, or lower court, directing them to perform a specific act that is required by law. It's typically used to compel the performance of a duty that one is legally obligated to undertake, but has failed or refused to do so. For instance, mandamus might compel a government agency to process a delayed application for a license. Then there's the writ of certiorari. This writ is particularly significant in the appellate process. A higher court uses certiorari to review the decision of a lower court. The term certiorari often surfaces in contexts where a case is elevated to a Supreme Court. This writ ensures that legal errors can be corrected, promoting fairness and uniformity in judicial decisions. Lastly, the writ of prohibition, as the name suggests, is an order from a higher court to a lower court or tribunal, preventing them from exceeding their jurisdiction. It acts as a shield, protecting against the misuse of power by ensuring that lower courts do not overstep their legal boundaries. Each type of writ serves a unique purpose, safeguarding liberties and ensuring governmental accountability. Writs are not confined to the shores of any single country. As we venture beyond the borders of the United States, we witness the fascinating ways in which other countries have embraced and adapted the concept of writs within their own legal systems. Take India, for instance. The Indian Constitution explicitly incorporates various types of writs under its Article 32. These writs, habeas corpus, mandamus, prohibition, quo warranto, and certiorari, are instrumental in the enforcement of fundamental rights. What sets India apart is the proactive use of these writs to address grievances directly linked to constitutional rights, a reflection of the country's commitment to maintaining a balance between state powers and individual freedoms. Moving to Canada, the landscape shifts slightly. The use of writs in Canadian law is deeply rooted in the English common law tradition. Canadian courts utilize writs such as certiorari to control administrative actions and ensure they adhere to the law. This mechanism serves as a vital check on governmental power, safeguarding citizens against any overreach. Down under in Australia, the High Court and Federal Court also employ writs to oversee governmental and judicial actions. Australian courts have effectively used writs like mandamus to compel public officials to perform their duties, ensuring that the cogs of government continue to turn in a lawful manner. Each of these countries showcases a unique adaptation of writs, tailored to fit their specific legal environments and societal needs. Despite the differences in application, the underlying principle remains steadfast across borders. Writs are powerful tools for upholding justice and legal integrity. Globally, writs continue to be a cornerstone in the fight for justice and legal integrity. In today's digital age, do writs still hold power? The question might seem archaic in a world dominated by digital communication and advanced technology. However, the traditional writ, a formal written order issued by a body with administrative or judicial jurisdiction, remains a cornerstone of legal systems worldwide. Its resilience underscores not just a historical legacy, but an ongoing relevance in modern governance and justice. Writs today serve as crucial tools in the enforcement of laws and the protection of individual rights. They continue to ensure that justice is not only served but also seen to be served. For example, writs of habeas corpus still function as a powerful safeguard against unlawful detention, compelling authorities to present an individual in court and justify their detention. Recent years have witnessed pivotal cases where writs have played decisive roles. In environmental law, writs have been used to enforce regulations that protect natural resources and public health. Courts have issued writs mandating governmental bodies to adhere to environmental standards or face legal consequences. In the realm of civil rights, writs of mandamus have ordered public officials to perform duties they have failed or refused to undertake. This type of writ has been instrumental in scenarios where legislative changes were needed, but were stalled due to bureaucratic inertia. Moreover, in the digital landscape, the scope of writs has expanded. Courts have adapted the concept to include digital writs that require internet service providers to block or remove unlawful content. This adaptation highlights the flexibility of writs in maintaining their efficacy and relevance in a rapidly evolving world. The impact of writs today extends beyond simple legal orders. They symbolize the enduring strength of the rule of law. They remind us that the principles of justice and accountability transcend the medium through which they are exercised. As we have seen, the stroke of a pen in writs continues to hold significant power in our legal systems. We have journeyed through centuries and across continents exploring the evolution of writs. From their medieval origins to their pivotal roles in modern legal systems, writs have been instrumental in shaping justice. They vary from habeas corpus, ensuring personal freedom, to mandamus, directing public duties. Globally, their adaptability has allowed for the upholding of rights in diverse legal landscapes. Indeed, writs remain one of the most potent tools in our legal arsenal, guarding justice one pen stroke at a time.